Thank you, Ms. McAllister. Mr. Schultze?
Good morning, Madam Chair. Commissioners, commission staff, commission advisors. My name is Jerry Schultze. I kind of serve in a unique role for the Morongo Band of Mission Indians in that I am the Gaming Commission, and I'm also the executive director of the gaming agency, the hands-on. Previous to that, I've been doing this now for about 11 years. Previous to that, I spent 27 years in law enforcement, retiring as a police lieutenant, and I started my law enforcement career as a regulator for the state of California, the Department of Alcoholic Beverage Control. When I was selected by the council, or appointed actually to be in this position, the council told me that they liked my background, which I was the commander of internal affairs, vice narcotics, detectives, and they wanted to show to the California people that they really respected integrity, which basically is the only thing I've got. Currently, we're running one Class 3 facility with about 2,050 slot machines. We can go up to 7,500, but as was mentioned by earlier panelists, the market dictates the number of machines. The tribe is a business. They run a business for the benefit of the tribe, so they're not going to have more machines than the business calls for. We also have two Class 2 facilities. One is our bingo hall with 50 Class 2 machines, and we also have a travel center with approximately 41 Class 2 machines. Currently, that business is run by Temple Tribal Enterprises, and it's going into a Class A business, which is pretty good for 41 machines. Our history with the electronic bingo aids, somebody called them bingo slots, they're not, but started probably in about 2002. Morongo had been doing session bingo since 1984, and along the way with the electronic machines, aids that Michael Lombardi mentioned when he was the GM, we kind of went into what we described as video lottery terminals. We had 1,627 at that time. When we signed the 1999 compact, Morongo was limited to 2,000 machines. In other words, we could only expand our business by about 373 machines, and our market at the time was much greater than that. As a way to generate business, and because the state of California would not negotiate with us for additional machines, we looked at Class 2. I, along with other tribal members from Pechanga, went back to Austin, Texas, and did due diligence several times, along with our attorney, George Foreman, on the whole Class 2 system. We also did due diligence by conferring with other tribes. Jamie Hummingbirds, my friend from previous mixed advisory committees. And after several months, I determined that Class 2 were allowed for the tribe to use. In January of 2003, at the Niagara Conference at Pechanga, I had Mr. Hogan and the Vice Chair, Nelson. I introduced them to the engineers from Multimedia, and they listened for approximately an hour and a half to the entire explanation of Class 2. And they seemed very interested in what was being presented to them. And I advised them at the time that I had just approved Class 2 being into our facility. Along the way, with our Class 2 machines, which are multimedia and two-touch, the council decided to expand from the two-touch into an actual video lottery terminals that were based on the multimedia New York State Lottery. Along with Pechanga, we had 1,800 of those machines into our new casino, which was opened up in December of 2004. Governor Schwarzenegger took office in November of 2003, and some other tribes were negotiating with different compacts, which required an extensive waiver of tribal sovereignty, agreed to certain compacts. We were then targeted by the state that these were Class 3 machines, slot machines. In our compact, as well as your compact, we have sections that we can meet with the state. Section 9 is meet and confer, Section 11 is major breach of compact. The state served notice on us of a violation of 11, not a 9, and went to a major breach. We had several hearings with the governor's legal affairs secretary and staff where we provided expert witnesses, etc. And their final determination was that, yes, the machines were not slot machines, they were lottery, electronic scratchers. But since the state of California could not use gaming themes, neither could we. Even though we made a presentation of all the scratcher tickets that the state had provided, which had symbols like Blazing 7 based on the Bally technology, et cetera, et cetera. The state then said that they would not proceed against us as long as we reconverted, either removed those machines or reconverted them to Class 2. We then, George and myself, discussed this with Mr. Hogan. We were directed to Penny Coleman, the acting chief legal counsel for NIGC, and we expected it easy to get a letter to go back to the Class 2 machines that we previously had. Ms. Coleman said they would not provide that letter, that since the machines had been converted from Class 2, that they needed a lab to come out to inspect them, which ended up being Nick Farley. And further, that since she and the commission, even though they weren't published, had come out with new rules, actually meant to slow down the game, we were forced to have multimedia come up with new programming, which removed a lot of the intermediate game prizes. And also, we had to use a 3-touch system. 1 touch to start the game, 1 touch to daub, 1 touch to collect the prize. 3 touch. As far as I know, we were the only tribe in the country that were forced to do this. We further were required to submit a letter to NIGC promising that we would stick to this in order for us to get our letter. Finally, we received a letter written by Penny Coleman. It was sent to George Foreman, a copy to myself, which we submitted to the state, to the legal affairs secretary, and at that point, we started again with the Class 2 machines. Subsequently, we entered negotiations with the state, which was long and a drawn-out process, finally ending in, I believe, the election in 2008, where we were allowed amendments to the original 99 compact, which allowed us up to 7,500 machines. In the meantime, our business still demanded that we needed Class 2 machines, especially on Friday and Saturday and Sundays. They served to provide a experience for our customers because the regular Class 2 machines were pretty much full at that time. When we got the compact, we then removed in 2008, we removed the Class 2 machines and replaced them in our main facility with Class 3. It took us 2 years, though, of discussions with NIGC over the process of stating how unfair it was that we were the only ones that were forced to use this 3-touch slow system, and that seriously was dampening our extra revenue that the tribe could use. At one meeting we had, which was a consultation per Mr. Hogan in Palm Springs in 2006, my legal counsel, George Foreman, was going over the unfairness of it, and Mr. Hogan admitted that it was unfair and they were looking into it. Mr. Foreman then asked the chair, basically, what constitutes bingo? How long does a bingo game take? And we kind of got the typical Chairman Hogan runaround response, if you know Mr. Hogan. And then Mr. Foreman asked, can a bingo game be done in 2 seconds? His response was, how can I go to Senator McCain and tell him that I've just approved a 2-second bingo game? That was his response. After a year, we finally were allowed to be like everyone else in the country and operate 2-touch. Although we never got a letter advising us that we were released from our promise, I did get a letter from Penny Coleman thanking us for our integrity, and where some other tribes didn't have the integrity, and that we had stuck to our initial promise. During the time that I've been there since 2001, I've been a member of the Mix Advisory Committee, the first one in 2001 that revised the 1999 mix, which, as you're aware of, were nothing but Nevada standards. And our first meeting in Washington in 2001, the Tribal Advisory Panel, which consisted of about members, regulators from 9 tribes, informed NIGC that we not agree that they had the authority over Class 3, but that we recognized that mix were important, as was evident by NIGA actually coming up with the first tribal mix several years prior to that. And we felt that it would be good for new tribes getting into gaming to kind of have like a blueprint. The mix was changed. It was not entirely Nevada. We looked at every mix in the country, and we also put out comments and received hundreds of comments from tribes, and everyone was reviewed and responded to. Terry Paust was the commissioner at the time, and she was the chair, along with Jamie Hummingbird as our co-chair. We worked hard on those mix, and again, we advised the commission, again, it's in our preamble, that we didn't agree they had the authority, but again, we thought it was probably a good thing for Indian country. I was then selected to another term in 2003, and the commission had changed. Chairman Hogan was the chair at that time. His first meeting, he advised us that he was appointed by the President of the United States. This was not a democracy. He would listen to what we had to say. However, if he disagreed with us, he was going to do what he thought was right. That set the tone. During that several years, we kind of just banded around with some topics, but the majority of us, I mean, Patrick Lambert, who's the director for the Eastern Cherokee, told Mr. Hogan that he was going to quit because we were nothing but window dressing. Along the time, about 2007, end of 2006, I was appointed for a third term, and as a standing member, and my term was to expire in December of 2008. Somehow they brought us together with the TICS committee, which Jamie was the chair of, and at that time I believe the TICS committee only had 4 members left on it out of frustration. And we were advised to come up with a set of mix in conjunction with the TICS members to go along with basically Class 2 gaming and other Class 2 issues. We started meeting, we spent hundreds of hours, and we had at our assistance a lot of tribal attorneys that are expert in Class 2, Mr. Harris, Judy, a few others, as well as the executives from, and I call experts, from the manufacturers, and particularly Skip from Rocket Bingo, and IGT was there well represented, and also we had multimedia, and we had the gaming laboratories. We had GLI, BMM in attendance, and we put in 12, 14-hour days continuously. We were finally told to come back in February of 2008 for a final meeting, and at that time, all the work that we had put in, and a lot of hard work, actually, the final product that they presented us was nothing that we recognized from our previous efforts. Then Chairman Hogan started the meeting with telling us that this was a tribal government-to-government meeting, and we immediately stopped the meeting and advised him that this was not a tribal consultation, that we were merely advisors with our background in gaming, and it did not constitute what was required as a federal consultation, government to government. In fact, during all of our meetings, no minutes were ever taken, which were at our first meeting, who had regular meeting notes. No notes were taken. I believe, and others believe, that they really were violating any federal policies that were out there in regards to note-taking for federal meetings, etc. Well, the meeting lasted one day. They came up with their final regs for Class 2, along with 3 other topics, several which we have never even seen or discussed. And then basically the panel and our committee was disbanded, even though, again, I supposedly had 9 more months in my term. A new advisory committee was selected, and they had to, in their nomination request, agree that they were actually speaking for the tribes for their tribes and could be construed to be government-to-government consultation. None of the members that I've been on through years, who are pretty renowned, I believe, in Indian gaming regulatory, agreed to even participate in that. During the time that I was dealing with Penny Coleman about trying to get a letter, she made a comment to me, several comments I think are interesting, you'll find interesting. When I was going over why we were being forced to submit to this, she told me that, what do you care for? Class 2 is dead. Class 2 was never intended to be in casinos. I think that's a pretty mindset that Penny had, and also I believe that Chairman Hogan and the other commissioners basically adopted. So as of right now, as I said, we're running a Class 3 facility and 2 Class 2, and since I've attended this 3-day hearing, I also have learned a lot. I've really come away with the importance of Class 2 gaming to Indian country, not only for the economic value, but also for the tribal sovereignty, the ability of the tribes to regulate themselves, to hold their heads high. I've really come away with more of that. And the Morongo Band supports all their other tribes in the efforts of this to retain that sovereignty and to retain their dignity. Thank you.
Thank you, Mr. Schultze. We'll now move on to the question and discussion. Commissioner Eckel, do you have any questions?
I do. I have a couple of questions for the panel. Does the regulation of electronically aided Class 2 gaming pose any different or greater challenges than regulating Class 3 slot machines?
I think it's it's just different. Class 3 is different. The terminology is different than Class 2. In our working on this committee, the advisory committee as well as the advisors were very strong in making sure that their mix represented the actual game of bingo, not Class 3 games. So it's just something different, and you can regulate both.
What have you found to be the most difficult part in determining that a given game is in fact a Class 2 game?
Well, for us, it has been making sure that the games are strictly adhering to those 3 basic requirements, and that the enumerated 4 criteria that has been spoken of are met. Absent that, Class 2 gaming itself is deceivingly simple in that the criteria are few, but those criteria all have to be met, or else you don't have a Class 2 game. So the reviews themselves, it's very critical that tribes are able to, without any doubt, identify all the basic elements that you need for a Class 2 game. And I say basics. The arbitrary criteria by which games have been boxed into what I guess the prevailing thoughts at either NIGC and or DOJ or anywhere else are taken from things that have been prevalent in the industry for a number of years. But these are features that are added to and that are changed over time with different variations of the game. There are no basis for these requirements, as I've said earlier. So when we look at it, we make sure that it meets the basic. We don't try to add. If there are additions on top of what is offered in the game, those are not necessarily as critical. You know, we do continue to observe and document the various aspects of the game, but they're not as critical to making a determination as finding out whether or not it does meet the statutory criteria and that we can successfully defend it in and out of gaming environments.
Thank you.
As Jerry said, it's different. there is as much rigorousness that goes into making a determination if a game is truly Class 2 as goes into determining if a game meets the standards, the definitional standards that are in our Tribal State Compact. There actually is quite a bit of descriptive information in the California Tribal State Compact. It's evolved and changed. The newer compacts have more descriptive language of what constitutes a Class 3 game, but I'll just offer you one observation about the difference that Jerry Schultze alluded to. In our particular case, with a Class 3 game, we're looking, as a gaming commission, we're looking closely at the board inside the slot machine that contains the EEPROM chip. Our focus is on the EEPROM chip, the erasable programmable memory chip. And I know the terminology is changing all the time. You struggle to try to stay up. But as you know, on the board of a slot machine resides a chip that the Gaming Commission is supposed to rightly be in possession of at all times. And we store those and lock those up, and when a game goes down or a change is required on a device on our floor, the slot manager has to come to us to get that chip. And like all of you, we spend an inordinate amount of time with our Cobatrons, checking the electronic signature from that EEPROM chip, and then verifying through GLI that that electronic signature comports with a game that has been certified and checked by GLI. And we look to see if it's if the chip is obsolete or if the chip is current. There's a lot of discussion in California about that nomenclature. I'd like to point out that we recognize that an obsolete chip does not mean that a chip does not function fairly and safely. It simply means that that manufacturer has created another version, just like on your laptop. Some of you have Vista and some of you have Word. You know, we don't want to go out and have to buy a new slot machine every time our vendors improve the quality or the contents of these EEPROM chips. Those chips reside separately and independently on the board of all of our Class 3 slot machines. If all the other slot machines in the casino go down, if 799 of our slot machines go down, and one slot machine continues to function, that's because it is independent of all the other machines in the colony of our Class 3 games. What we look closely at in the games that we've been discussing with vendors that would qualify as Class 2 is the server. The server. You've heard here one of the characteristics is if you unplug the machine from the server, you know, it's like it's on life. I think of the Class 2 games, they're on life support. If you unplug them, they die. Okay? A Class 3 machine doesn't need a ventilator. It can run by itself as long as it's got electricity. So a Class 2 game would never be able to have a chip that drives the game reside on a board inside of that box independent of all the other boxes that constitute the network of Class 2 games. So I think one of the things that we look at rigorously, we've talked with laboratories, we talked with the manufacturer is, hey, what's in the box? You know, and how does it work? And how does each game that's part of the network interact and communicate with that box?
Thank you.
Yes, thank you. Before I turn it over to Commissioner Pettiford, we have many questions up here and about 25 minutes left, so if we could just shorten the answers a little.
It wasn't just you, Michael.
No, wasn't, but we want to be able to ask as many questions as we can.
We understand.
Commissioner Pettiford?
I just have one quick question. In your view for the whole panel, what are the top 2 or 3 challenges tribal gaming commissions face today in regulating Class 2 gaming?
Dealing with people with no gaming experience on
Bravo.
various levels.
All I needed. Thank you.
Mr. Foreman, do you have any questions?
I do. First, for the panel, has it been your experience that the NIGC seems to treat some vendors differently than others when conducting game classification reviews?
I have seen a notable difference in how some vendors are treated versus others, and the fact that that does happen is disconcerting at best. But the fact remains, depending on who you are and what game you have, will depend on how the NIGC reacts to your product.
And does it seem to you that they are more aggressive toward Class 2 game vendors than Class 3, or does it cut across both categories?
Definitely more aggressive towards Class 2.
I agree.
Ms. McAllister, is the Lucky Lotto game currently in play in Oklahoma?
Yes.
And there's not been an NOV?
No. I think it's impossible even for the NIGC to issue an NOV, based on their communications and, the fact that they're finding it was a Class 3 game is based on regulations that are not in existence. So it's still out there, and it's a really valuable game for the tribes.
Thank you.
Class 2 game, I might add.
Yes, thank you. Primarily for Mr. Lombardi, but if other panelists have thoughts, they should jump in. You spent a lot of time talking about a critical distinction being between Class 2 and Class 3, being that the Class 2 electronically aided Class 2 games are server-based, whereas the Class 3 games are EEPROM within the box. What do you think will be the impact on you as regulators with the advent and growth of server-based Class 3 games? And what regulatory challenges will that pose in distinguishing between a server-based Class 2 game and the kinds of server-based Class 3 games that are being developed in the industry?
They'll be enormous, Mr. Foreman, and I'll be brief so the other panelists can talk about that question as well. Let me just point out to you that isn't it ironic that the line is being blurred by the Class 3 product coming across the line and usurping technologies that have been used for many years on the Class 2 side. I find that most ironic. Let me try to answer your question this way by pointing out one function that both the Class 2 and the Class 3 networking gaming will share in common, which is player clubs and player cards. This will be a dynamic in which both Class 2 and Class 3 will be able to share similar technologies. Indeed, I doubt that any of our casinos today would survive without our player club cards, would they not? You think about it, is that machine jumping today has been accentuated by cashless wagering. I believe that it's increased the amount of play time, the amount of time and money that people spend on machines, is that they can jump from machine to machine without taking a bucket of coins with them. In the Class 2 realm, this is going to stay the same. It also allows us to track our players, to know who our big players are, who's spending how much and when, and to send them special promotional offerings. This will be an aspect of tribal regulation in which there'll be virtually no difference between Class 2 and Class 3. And I believe that the technology is foreboding, to say the least, because my understanding is that in a Class 2 network, all of the machines will be running off of 1 or 2 processor chips, where in the case of Class 3 gaming, theoretically, every single machine on the floor that is Class 3 will require to have its own unique chip inside the box. So this is going to mean we're going to have technical people that are going to be able to find those chips and identify them and track them. And this could be a technological challenge that may very well exceed the technical capability of our gaming commissions. So I'll end with this, that when that happens, the budgets of our tribal gaming commissions will increase significantly.
I'll just add on to that. I agree with Michael's assessment that the technology itself is going to present new challenges for tribal gaming regulators, and we are definitely going to have to invest more in the way of information technology personnel within the commissions. But for those of us that have been in the Class 2 gaming industry for a while, I think simply by the fact that we've had these server-based games for practically ever, puts us in a little bit of a better position, ironically, to deal with the coming server-based platforms that you will see in Class 3 gaming. Since we have experience with server-based technology, there are going to be differences, yes, but the fact that the network, the platforms, the infrastructure is not foreign to us will actually help us make that transition into server-based game for Class 3s.
Let me just clarify, and then I'll be finished. The thrust of my question was not necessarily the technologic or the regulatory challenges imposed by technology per se, but rather if you have a server-based Class 3 system where you have downloadable games going out to terminals, how are the regulators going to be able to tell whether a game being played on a particular unit is a Class 2 bingo game operated by a server or a Class 3 slot machine game operated maybe from the same server? Or are you going to have separate servers for Class 2 electronically aided games and for Class 3 slot machine games? That's the concern. If you look at it, how are you going to be able to tell which game is being played?
Well, you're going to have all kinds of servers. You're going to have servers for Class 2. You're going to have servers for every manufacturer game on the floor. One problem that I see is perception of integrity. I don't know how many times I've had people say, hey, which machines should I play? Oh, yeah, I'm winning, so you guys are turning it off, so I can't win, etc. I mean, you're playing a machine, and 5 minutes later, it's a completely different machine. I mean, these are major issues. And another thing that, as a regulator, I'm not too happy with is the ability of that manufacturer to be able to go into your system, to download. I think there needs a whole lot of fire blocks and stuff. So the only thing they can do is maybe change the theme of the game and maybe change whatever the coin is. And then on top of that, the accounting nightmares, because we're required every time you have a multi-denominational game, it's been a nightmare for years attributing to whether or not that part of the game meets the 4% rule, you know, as far as if it's biased one way or the other. It's a whole lot of nightmares. And right now, I don't think it's really going over that well in the testing stage.
Thank you.
If just before you, Jamie, that let me also say, Mr. Foreman, probably server-based Class 3 gaming is probably a long ways in the future because of the cost. We've seen in the Nevada gaming market, it hasn't been embraced thus far, despite the efforts of manufacturers, because in this down economy, most operators don't want to spend millions of dollars for a new technology. And one last point, I'm not sure exactly how it will work, but as a gaming commissioner, as Jerry said, there'll be lots of boxes for different vendors. But one critical difference that we will have to discern as regulators between Class 3 boxes and Class 2 network boxes, the random number generator that generates the outcomes for a Class 3 game is on the same board that the EEPROM chip is on. I would surmise that in the case of a network Class 2 game, the random number generator will be separate from the chips that drive each of the individual machines, and that'll be a critical architectural difference that we will be able to readily discern.
And to tack on to that, I agree with the other two gentlemen here that the Class 2 systems will be on their own separate network, if you will, their own separate servers. I don't think any manufacturer out there would allow their games to reside on the same server as another manufacturer, so I foresee each individual game provider being on their own individual servers. But that goes back to the point of the gaming commissions being able to readily discern for themselves and verify that those do not cross paths, only unless there is some agreed upon back of house system, online accounting system or what have you. But the fact that we're going to have this eventually is something that is before us right now as an opportunity, because the challenges that we're going to face, whether it's going to be accounting or technology-wise or compliance with internal controls, those types of issues are very much in our hands at this point. This is developing technology. This is the developing next evolution of gaming. And I think it's going to be incumbent upon tribal regulators to be the ones to look at and define how we are going to approach the introduction of server-based gaming.
Mr. Verlandra?
At the risk of testifying, I think the answer to George's question is quite simple. We have the game of bingo, and then we have random number generated games that are entirely different regardless of technological similarities. So maybe I'm just naive about that, but I think that's, again, at the risk of testifying. Taking it a little different tack, I'm going to break my questions into two pieces, some broad and philosophical, and then a couple of more practical questions. On the broad philosophical realm, the fact-finding hearing is gathering a record, as all of you recognize, that hasn't existed before. It gives a basis of fact and information for the Sycuan Gaming Commission to make decisions in the future, and for others if they so choose. But the challenge, I think, one of the challenges, and I think Jamie hit on it before, and Michael really hit it right on the head when he talked about comedy, the comedy of finding commonality among the tribes, trying to find that comedy with, hypothetically, this factual basis as a starting point, and process and substance. Because as we all recognize, each tribe has a little different view of things, has a little different interest, different political pressures, etc. In your view, again, briefly, how would you see comedy of process and substance coming together so that over time the view of Class II gaming from a regulator's point of view is similar, or there's at least, is similar from California to Oklahoma to Minnesota to wherever else it may end up?
Just to see if I can condense all the thoughts that are going in my head down into very short. One of the things that is going to be important for us to do is to focus on our respective jurisdictions. I agree. I think there needs to be some commonality amongst all tribes, maybe a common foundation for reviewing and assessing Class II games. And that is something that through my organization, I hope that we might be able to offer a forum for us to do just that. In fact, at the next conference that we have in the fall of this year, I would like to have a discussion to further the discussions that we're beginning here today, to kind of maybe set the stage for making that foundation and finding out if there is going to be a common platform that we can all accept. But realizing too that our respective jurisdictions are also going to impact what is going to be built upon just that foundation, because what's true in California may not be true in Oklahoma, may not be true in Alabama, may not be true in Montana. So if we can find that commonality, that common ground, I believe if we can come together as tribes and do that, it shows the unity that we need to have whenever we are faced with challenges on Class II, whether it be in one jurisdiction or another. That way, our detractors cannot say that they are doing it this way in Oklahoma, but they're doing it this way in California or this way in Wyoming. We need to have one way as much as we can so that we can all be in support of each other, and that way they do not divide and conquer.
Thank you. The next question is mostly a California question right now, but it's sort of raising its head elsewhere, and as compact negotiations begin in Oklahoma in a few years and elsewhere, I would like to ask the panel their view on the relationship between the definitions of Class II as we understand them and the definitions of a gaming device that might be contained in your compact. As I say, we're running into that now, and I'm wondering if you think there is a relationship. I related to one of the panels a couple of days ago that there's an argument that Chairman Hogan has advanced recently that whatever is Class II is necessarily constrained by the definitions that would be contained in a Class III compact. I don't buy the argument, I'll just say that, but I think there are those that out there that do like that argument. In particular, the states may like that argument.
I'll be brief. I'd like to really hear Jerry talk about this, but actually, Mr. Valandra, that is becoming a problem in California because, as was alluded to, I believe, yesterday by a witness, there are charities in Sacramento that are offering games that clearly are slot machines. I'm not a lawyer, but it's my understanding under the penal code would constitute a slot machine under California state law and should be exclusively available only to tribes operating in conjunction with a tribal state compact. And I think there's a exquisite language in the original compacts that explain and define exactly what a slot machine or gaming device is under the Class 3 gaming device under the compact. And indeed, we've seen with each new amended compact, the state adds more and more definitional information to the definition of a gaming device. That's because the fundamental problem that this hearing, I think, has done an excellent job of elucidating is that your question is so hard, and Mr. Foreman's question is hard because it's a moving target. Because every 6 months, the technology, once we understand the technology, it changes again and again. That's a blessing and a curse at one and the same time, and that behooves all gaming commissioners to try to stay up with the technology which is occurring at breakneck speed. It's a very general answer. I was probably not satisfactory, but that's why your earlier question is so vitally important. I was really glad to hear that Mr. Hummingbird, we talked about it earlier, is talking about holding an entire session at their next meeting that would discuss and talk about the findings from this hearing. I suspect that at the National Indian Gaming Association, at the World Gaming Expo, at the next CNIGA conference, this hearing is going to be the most talked about event in Indian country in many years, and that the findings that this commission and the staff will finally put together are going to be perused over and over and talked about. I think we're starting a dialogue here today that will accomplish what it is you're talking about.
This is my opinion. I'm not speaking for the Morongo Band right now, but this is my opinion, is what I've seen and stuff. The state of California wants money from us. They don't want Class 2 because they don't get anything out of it. I think you've seen some events locally here where the tribe decided that it wasn't in their best interest to go along with this basically forced compact and decided to use Class 2 as an alternative. And the threat that was posed to them, that if they didn't remove these machines, then they might get a notice violation, etc. So in my opinion, just from my observations, I think the state of California would like everything to be Class 3, so they get a cut.
That's probably true in most states, actually. At least whether you get a percentage of gross or net revenue, I'm sure that's true. Now, just a little more specific, I know we're running short on time, but we're talking about, we focus a lot about bingo, about the three elements of the game commonly known as bingo. But any of you that were here yesterday with the history of bingo panel saw that bingo is played and has been played forever in a variety of ways that some of us probably had forgotten. In particular, some of the questions I asked about the instant bingo games, the bonanza bingo games, now those are games that if they're implemented and approved by tribal regulators, because we know at least with the current commission there's not a chance that a bonanza or instant bingo as it was described yesterday would be approved. But if it were, I think we have to be mindful, and maybe this is more of a statement than a question, but your view on this, that as the facts and the findings of this hearing go forth, and there's a realization that there's a business model that's profitable for somebody, in particular the tribes, by implementing an instant bingo game, a tip jar game, as probably none of us had ever heard it described until yesterday the way it was, or a punch board game the way it was described yesterday, in a form that is profitable and fun, that we have to be mindful that there's more than just the game of bingo under Class 2. And I don't think you run into that very often, but I'm curious of your view of it as a tribal regulator and how you think that'll shape the future.
Well, as we were going through this technical standards advisory committee piece, that was one thing that kind of struck me as odd as we were talking about the impact of those standards on not only the electronic form of bingo, but on the paper form. And correct me if I recall this incorrectly, Joe, but when we were going through that, I believe Nelson Western and Commissioner Choney and Chairman Hogan and even to some extent Penny and Michael, they all said this has nothing to do with paper bingo. It's not our intentions to affect paper bingo. We don't foresee this affecting paper bingo, even though we found out, yes, it's going to affect bingo minders and the like. But that's the odd piece, though. If it's not intended to touch paper bingo, then whatever happens in paper bingo, or what everybody knows as bingo sessions, whether it be you pick'ems, bonanzas, any of those forms of bingo, should translate over to an electronic form. But we also found that the NRGC had no firm concept of what constitutes a variant of bingo, and even has gone so far as saying that in order to be a game similar to bingo, you had to have all the characteristics of bingo. I still don't see the logic, but as a tribal regulator, if I were, and we have approved you pick 'em games, we have approved bonanza bingo games in the past. I would stand behind them to this day. But what we have to have, to go to Jerry's point, is to have somebody that has experience and knowledge on gaming, rather than somebody sitting in an office in DC trying to tell us how we can run our games out here on the floor, because we are the ones that know what's going on with these games. We know what it takes to be a Class 2 game. What happens in paper should be able to happen in electronics.
I think maybe this is where the requirement that the vendor pay for the litigation might be valuable.
Yes, I would imagine, it probably might be, but that's part of the business model that has to be considered, I think.
Are there questions? Yeah. Madam Chair, I have a question. Oh, Yvonne, go ahead. Okay. All right, I have a question for Nancy McAllister. Earlier in your testimony, you spoke of joint conferences, and I was wondering how helpful you think it would be if a tribal regulator, upon showing up for that joint conference with the NIGC, already had classification regs that were drafted by the tribe. How helpful would it be to get a positive outcome from that joint conference?
You know, that's a difficult question to answer, actually, because we did have regulations when we showed up for our review, and I'm not even sure that's going to play a part, but it would play a part as far as your record, to show a rational basis, obviously, for your opinion. Would it sway the NIGC? I'm not sure. Most likely not.
Thank you.
I have a few questions. First, from Mr. Lombardi. What year did Morongo introduce his video bingo, and can you describe how that system operated?
Yes. 1989, there was a device, there was a company called Fortinet. It was a small company of immigrants from Russia who were Jewish that had fled Russia. Yuri Itkus was the president, and he designed a clunky wooden box that had a video screen on it and a computer underneath it in a box. And there was a cord that came out of the box like a gooseneck, and it had a fiber optic wand on the end that when you pressed it against the screen, it created a light that then marked different spots on the screen. Utilizing that, and that device was connected to the bingo floor. And when the caller would stroke in the number using a keyboard, it would send that signal to each of those devices. As people marked the cards, every card that contained that number was marked. The best card would be displayed, and it would notify the player when they had a card that had accomplished the pre-designated pattern. That was 1989. They had a patent at that time. They were unable to defend that patent, and many other companies would flow in and take that idea of connecting a computer to a blower. Let me just add that in 1989, we had 4 in a corner. and we only allowed handicapped people to play them. I've been in bingo for many years. I must tell you, I was shocked at the number of people that came to me that told me they had rheumatoid arthritis and daubing all day long was a very uncomfortable experience, and that I had rejuvenated their life because now they could play their favorite game as much as they wanted and only had to daub a number once. The crossing the Rubicon of electronic bingo occurred when 1,800 people sitting in a bingo hall at Morongo accepted the fact that the first person to ever win a bingo game on a computer was real. That what was in the box was as real as what was up there on the blower stand. It was a young man. He was about 33 years old. He was a wonderful gentleman. He was African American from Los Angeles that came every day on the bus, and he was limited to a wheelchair. He was a delightful person. Everybody in the hall loved him. I remember to this day that when George won the first bingo to ever be won in an Indian casino on an electronic system, everybody stood up and gave him a standing ovation. It was the first time he had won. He would pass away about 3 months later. From that point forward, Morongo rapidly began to install more of those machines. We were competing against San Manuel. It was tough. I discovered that with 116 of those Fortinet computer devices in 1989, I could generate as much per head spend as 600 paper players would generate for us. It saved Morongo Indian Bingo and spawned an industry that we see as a billion-dollar industry worldwide that would go from that clunky box to handheld devices. Who could have envisioned that the computer technology would change so much so fast to take that simple idea and put it in the hand of a person where they would now be connected by Wi-Fi?
Thank you. My next question is, what is your view of the role of the NIGC in regulating Indian gaming overall? And how would you describe your gaming commission's relationship with the NIGC? This is for the whole panel.
Let me first answer the second question. As far as the relationship between my commission and the NIGC, we have a very good working relationship with the regional staff. We have an arm's length relationship with the headquarters staff. But to answer the first question, the role of NIGC, as I mentioned earlier in testimony, is I think that they have gotten away from what their role was intended to be, and that is basically hands-off, at distance. In the past few years, what we've seen them is being hands-on and trying to actively steer the course for tribes in regulation of Class 2. They were never meant to be in our facilities making determinations by way of regulation on how we operate our facilities. Their role was intended to be oversight and monitoring and assistance, not to go out and issue basically what amounts to a usurpation of tribal gaming regulatory decision-making authority. The fact that we have the level of standards and the level of regulation that we do speaks to that. But their intended role, in my view, was for them to provide assistance to the Cherokee Nation, to Sycuan, to the Seminoles, to anybody that might need it in whatever area they might need it.
I agree with Jamie. We have a great relationship with the regional staff and a so-so with Washington.
For Augustine, our field investigator, Manny Sanchez, periodically comes out and conducts spot audits. I want that on the record because it's been asserted here in California that there's a void and the NIGC is not doing their job. We've had 2 oversight audit visitations by Manny Sanchez at Augustine that went through our independent certified public accountant agency mix audit and financial audit, as well as spending an entire day with our internal auditor, and they were most pleased and most satisfied with the results. The other things that we do, of course, is all of the gaming commissioners do, is provide the National Indian Gaming Commission with our annual audits. That still continues, and that's done almost automatic. And of course, the most important thing, I guess, to the commission is to make sure that we pay our annual fees. And that's the extent of our relationship, paying our fees, turning in our audits, and field investigators that usually visit us 3 times a year. And I would say the relationship with the field investigators is outstanding.
Even though I'm not currently a regulator at a tribe, I represent some tribal gaming commissions, and I think that generally speaking, the tribes have a good relationship with the local people and not so good with the headquarters. And I believe that in order to resolve the problem with headquarters and the overstepping of bounds that I think has become clear in all the testimony that's been presented to this commission, I think it may be take a joining together of the tribes to ratchet the NIGC back to their described role, to monitor and, and observe.
Thank you.
Yeah, this question is for the panel. And as regulators, are there ways in which the introduction of Class II electronic aids have aided your ability to ensure the integrity of the game of bingo?
I would say yes, just by the fact that we are able to, through all of our efforts to document and to go through all the due diligence efforts that we need to do to certify a game, we can say without a doubt to our tribal councils, our administrations, anybody in the state, our patrons, we have done everything that we can to make this game as fair and as equitable to everybody that has an equal fair chance of winning, just as you would in any other format. It has aided us to help ensure that we do fulfill our obligation for that second piece that I mentioned earlier of ensuring the integrity of the game. We do that with great conviction and through a lot of detailed analysis. So yes, I think it does help.
One of the greatest challenges for Indian tribes in the early days of Indian gaming was protecting the paper. The development of perpetual audits have saved tribes millions of dollars of paper that was skimmed and then sold on the floor. That was a problem in the early years of Indian gaming. I would say that virtually has come to an end as a result of tribal gaming commissions and the introduction of computer technologies that make it ever so much easier to account for all of the paper that's being played on your floor. You can imagine that if a person purchases 256 cards on a computer system that is immediately downloaded to your server and can be summarized in a very comprehensive report at the end of the session, that is a much easier process than having to hand count every single piece of paper that you put out and every single piece of paper that comes back in and then account for the sales of that. Yes, indeed. One of the greatest advances of Indian gaming has been the incorporation of computer technologies in conjunction with Class II gaming to increase our accounting, the confidence of our accounting.
Thank you.
Any other questions?
I have one more, if you please. When the accounting, or when the grandfathering issues all go away and the current NIGC mix and current technical standards are fully applied, and I come to your gaming commissions with the original multimedia game that doesn't have enough intellect to do all the things, but it has a 10th Circuit Court opinion that says it's a Class II game, or I bring you a Lucky Tab game, which doesn't have enough electronics for you to test at all, what are you folks going to do? Again, they have Circuit Court approval, but they don't pass the NIGC mix, and they do not pass the NIGC technical standards. What are you going to do?
I think that would be the point where you exercise your own judgment and act as the primary regulator, and if you feel that it's a benefit to your tribe and your operation to play those games, then you would play them.
I agree. If 7 years from now, we are presented with a magical Irish type game, Lucky Tab 2 type game. I think the commissions all across the country that's faced with this, they're going to have to do that. They're going to have to exercise their own judgment. Is it best to go with legal precedent and challenge the existing language of regulation issued by NIGC? That was the criticism that we offered up through that process. Was not only was NIGC instituting arbitrary criteria, but they were completely undoing the progress that had been made through the Circuit Court and Supreme Court decisions. I didn't think they have the ability, the power, the authority to do that. Nonetheless, we are faced with those regulations now. So in 5 to 7 years, if we're faced with that, tribal gaming commissions are going to have to make a decision. Do we challenge with the court precedents, or do we go along with the regulations?
I think depending on the region of the country, could be a business decision too. The cost, the benefit of having that machine versus the cost of going to federal court, I think that must be weighed. But again, this is not all fits everything. You know, we're different in California than Oklahoma or Alabama or Florida or whatever. So it might not make financial sense to us where it definitely would make sense in Oklahoma.
Thank you.
And that factor that Jerry's talking about, the other technical issues aside, is that fundamentally, you're only going to put Class 2 games on the floor that are going to make money. And the reality is that's not a gaming commission decision. That's up to operations. But I have to tell you, after being in the business for a few years, you never know which games the players are going to embrace. And that's a fundamental problem that can only be resolved by actually putting it out there and letting the players try it out.
I have one more follow-up question I'd like to ask. If I come to you with a game that passes the mixed standards and passes the technical standards, and but it has this requirement. In its game description, it describes that the player participates in the game by pushing the button down to initiate the game and holding it to dob the game, and the player must hold it until they reach a win, and they claim their win by releasing the button. What's your approval position going to be?
Yes.
I would have to see what the legal opinion from the Green law firm has to say on that issue.
Touche.
I have one more short question. I think the answer is yes to this for the panel. I get the sense that yesterday Russell Witt testified that there were 2 tribes that he worked with that had put an additional layer of regulation, tribal regulation, on top of the technical standards. I assume, I'm asking if you would agree with that process, if you thought it was right for you.
Is the question, is it okay to add, or do you agree to add your own
Yes, do you
regulation?
agree that it's proper process for the tribes to add their own regulation over and above, or to modify and interpret NIGC regulations, for example, like the technical standard?
Certainly. I think there should be no hesitation to make your own requirements.
We have that in GLI 11 and 12 with the VAdvisors, and most of the manufacturers test for the more stringent. And, you know, I think any tribal gaming commission, they can tighten up their facility as much as they want.
The approach that we have taken has always been, if these are minimums, you know, regardless of whether we agree with them or not, they're minimums. And if we want something, or if we need something that's particular to our jurisdiction, then yeah, we will exercise that right to further refine or define the standards as we need them to perform in our operation, so yes.
That gaming commission function, I would say, is similar to the implementation of the minimum internal control standards. And I bet that most of the tribes in California's minimum internal control standards are stricter than the NIGC. They've been augmented over and over again for each of our own unique circumstances and situations. And I believe that that will probably be the case here in California with Augustine on our Class 2 regulations. They will actually be more stringent.
Yeah, I understand. I think the circumstance I'm thinking of within the technical standards are some of those areas that are yet a bit ambiguous in terms of interpretation, like the 50 million to 1 odds or the 100 million to 1 odds for the, exactly what does that mean? We haven't gotten a lot of guidance on what that means, and it may be a proper role for a tribal regulator or gaming commission to tell us what that means. That's all.
I would like to thank the Tribal Regulators Panel for this enlightening and informative discussion. This testimony completes our morning session. We will now break for lunch and reconvene at 1:30 with the Class 2 Vendors Panel. Thank you.